Hello, everyone. This is Tom Fox with our inaugural 2025 episode of the award-winning Everything Compliance. Today, we have the quartet of Karen Moore, Jonathan Armstrong, Karen Woody, and Matt Kelly. So welcome, everyone. And we're going to start today with Karen Moore. Karen, what do you have for us?
Thanks, Tom, and Happy New Year's to everyone. I reached around. It was, kind of quiet last couple of weeks, but I did find a mildly amusing, entertaining court case decision handed down on the 26th of December by the U.S. District Court for the Eastern District of Wisconsin, which decided on two summary judgment motions on two Title VII claims filed by a former employee of the Regional YMCA. The first claim is a pay discrimination based on gender, maybe not quite so exciting as the second claim, which is discriminatory termination under Title VII based on pregnancy and pregnancy-related treatment. So the first one, both of these, by the way, just contain some little small learnings to keep us on our toes, remind us that there is always something that we can take away and take a look and adjust what we're doing in our own compliance program. So first one, the pay discrimination based on gender. So this claimant, the plaintiff in this case, was a vice president in the YMCA, apparently had a successful career there for about 8 or 9 years with consistent promotions, consistent pay increases, consistent bonuses. But she learned that upon her elevation to vice president alongside one of her other district managers, that she was being paid several $1,000s less than her colleague. And she filed, among others, this Title VII claim for gender-based pay discrimination. Now, just reminding everybody that under pay discrimination claims, you have to provide evidence that there are common factors allowing for a meaningful comparison between what you're being paid and what others are being paid within your organization. So here, one of the complaints was that she was being paid less than her colleague. They were both elevated at about the same time, even though they had different responsibilities. So she went to the CEO of the organization, and that conversation resulted in a 4% merit increase in her base pay, which was still resulted in 1 to 2% below her colleague vice president. But she saw continued increases over time, and within 2 years, she was within a 1% disparity. Their bonuses over the years were identical, yet she still claims that there is a discriminatory pay gap between the two of them. So here we're taking a look at whether or not she provided common factors that allowed the court to provide a meaningful comparison. One of the arguments she made is that then when she and her co-vice president were branch executive directors, they had the exact same pay. But at that time, that was the exact same job. So the court took a look at the scope of responsibility of the two vice presidents. There was no job description. The titles were similar. However, the scope of their responsibilities were very different. Her co-vice president had more direct reports, had a master's degree, was responsible geographically for a larger territory. And even though they had similar titles, they had dissimilar responsibilities. And again, just a reminder, this is like a kind of 1% pay disparity. So the court issued a summary judgment, granted summary judgment to the defendant organization, finding that there was no evidence of gender-based discrimination. So, some small takeaways here. None of these are going to be surprises to anybody working in the compliance field. You need job descriptions. You need objective salary ranges with criteria. Why are there different awards within that range? You need to do pay audits to make sure that people are being paid appropriately. You need to have transparent discussions with your employees when you're making paid decisions, whether it's bonuses or base pay or others, so that they understand. These are HR related matters and management related matters, but like with all things, chief compliance officers and compliance professionals are uniquely positioned to take a different perspective and make small adjustments, double check, have conversations with the appropriate people. Are there learnings here where we could avoid these kind of pay discrimination claims by our employees? So that's kind of off the table. The second thing is a little bit more interesting and has a small, kind of either humorous or shock factor, depending on how you look at it. This was the second Title VII claim that the defendant made, which was that she was terminated in a discriminatory fashion based on her intention to become pregnant. She was undergoing a round of IVF at the time of her termination, and she filed this claim, by the way, before the Pregnancy Workers Fairness Act, which requires reasonable accommodation, came into full effect in June of this year. So she filed a Title VII claim. Just a reminder that discrimination under Title VII based on pregnancy is not just current pregnancy, but past pregnancies, planned pregnancies, potential pregnancies, and certainly would have covered her IVF treatments. So here the burden was on her to demonstrate that based on the evidence as a whole, she was treated differently than other people in her position, and that she was terminated as a result of her intention to become pregnant. So here she brought up the pay disparity again, which the court dismissed in considering this part of her Title VII claim. She said that the other vice president was treated more favorably in terms of his time off request versus her time off request for various treatments and more. But here's where the fun or the shock comes in, which are the anti-pregnancy remarks made by the CEO. He entered into a meeting in which he knew that the plaintiff in this case was intending to go for a round of IVF, and that two members of her team were already pregnant, and said, oh, there must be something in the water here. And by the way, nobody else on your team is allowed to get pregnant until we resolve the current pregnancy. So not really, really smart moves on the part of the CEO of the organization. The plaintiff claims that, after she informed the CEO of her intention, he first of all manufactured documents with HR together with the other vice president to document false instances of poor performance, so that there was, kind of a pretext created after the fact that there had been no feedback to her during her performance that indicated that she was not performing up to scratch. She also made the claim that these remarks were evidence of his bias against pregnant women, and that his decision to terminate her was really based on her planned pregnancy and had nothing to do with her performance. On his part, the defendant, the CEO, said, look, these were stray remarks, which I did not realize was actually a legal term, that they were stray remarks that were just off the cuff. They didn't mean anything. They had absolutely no bearing on his attitude towards pregnancy or pregnant women or intention to become pregnant within his organization, and that there was ample factual basis for termination. She canceled a bunch of meetings. She didn't show up for one of the board meetings. She had lack of leadership skills. They had third-party reports, including from her direct reports, as to her failure to implement strategic initiatives. So the court took a look at everything surrounding this, all of the facts, all of the documented evidence that the defendant came up with to show that the termination was based, in fact, on poor performance and not on pregnancy. And I think, based on the language of the decision, that the court may have granted summary judgment here and dismissed the plaintiff's claims and granted summary judgment in favor of the defendant, had it not been for these stupid comments here. And so it kind of looked more into these stray remarks because we all see them, we've all made them, we've made stupid comments in stupid contexts without any real meaning. But here, stray remarks can be considered circumstantial or direct evidence of intentional discrimination if, and the court named two things. One, that they're sufficiently connected to the employment decision in time, and that they by the decision maker close in time to the adverse decision. So here we've got the CEO who terminated this employee a mere few days after her initiation of the IVF. So the timing here is he made the bad remarks. She started her IVF treatments, and he started almost immediately collecting information on her performance a few days afterwards, and then resulted in termination decision a couple of weeks later. So that timeline, I think, starting with those bad remarks, combined with this kind of, adverse decision close in time made by the decision maker, caused the court to find that a reasonable fact finder, that is the jury, might conclude that the CEO remarks evidenced an animus towards pregnancies and that he ultimately decided to terminate the plaintiff because of her desire or expressed intention to become pregnant. So here we've got just really dumb offhand remarks, which have led now to a jury trial. Now, there are other, facts maybe that might have led the court to make the same decision to deny summary judgment and take this to trial. But here it really seems that those comments were the tipping point. And from that, I really took away quite a number of things that we need to think about. First of all, explaining the grounds for termination at the meeting, at the time that you're terminating something. It's not required, but if you explain these grounds and document them, it might ward off your chances of litigation. If you can really provide some factual grounds, let the employee, first of all, feel respected, but secondly, have a chance to contest them, because a lot of the facts here were based on kind of these third-party reports, lack of leadership. I mean, one of her comments was, I've been consistently given the same bonus as my co-VP. I've consistently had increases in my base pay. I have not had any prior poor performance reviews and the like, so that conversation can be had. So explaining the grounds, I know that that's unpopular in some circles. Some labor lawyers may disagree that the more you say, the more open you are. But here, and I think as a best practice, you could potentially ward it off. The other thing, which is the broken record for all of our HR colleagues out there, which is document poor performance, have a system in which poor performance can be documented so that over time you can build up a evidence-based, time-dependent documentation that says, look, there are gaps in our expectations. You were promoted to VP, you were given, adequate performance reviews, but we have high expectations. We were hoping you were going to meet and you didn't. Don't pay the bonus for heaven's sakes. Don't give merit increases for heaven's sakes. If you really feel that there's poor performance over time, make sure your file shows what you need there. And then, the injured party should speak up contemporaneously. She did not. When these comments were made, she had no evidence that she complained to the CEO or even to her colleagues, to her team, anywhere that she felt that those were inappropriate comments, that she was being treated differently, that her teammates who were pregnant were being discriminated against or inappropriately put in an uncomfortable position. And then here we get to the investigations learnings here. And, I'm always approaching investigations on the side of the reporter. Reporters come forward with concerns. I'm going to start fact finding, but I'm going to give them all the benefit of the doubt I can. And I've learned over time to be a little bit more cynical about that approach. You want to have an unbiased, appropriate, and fair investigation. So had she spoken up earlier to somebody who is in a position to investigate, you could start establishing a clear record defensively that these remarks were taken seriously, that there were reactive counseling or other measures taken, that stray remarks need to be taken seriously. They shouldn't be made, and that they're inappropriate, especially when taken by a senior leader. The reporter then could have been placed on a retaliation watch list, so that if there are labor decisions that are being made, they're being made consciously, under scrutiny, with an examination of the facts, with a separation between things like stray remarks and a factual basis for termination. So an investigation would really have helped. It can also inform the broader training and communications regarding discrimination. I always think it's really important that compliance play a role as people elevate within an organization into positions of responsibility, that you talk about the loneliness at the top, the kind of increasing in loneliness as you become a manager, a senior manager, a director, and for heaven's sakes, the CEO of an organization, that what you say has a lot more impact, that you've got to watch what you say. So, the investigation, had it taken place, could have had a nice balance between protecting the reporter, the VP in this case, but also defending the organization by creating an appropriate record. So, stupid comments here. I don't know what's going to happen when this goes to trial. Watch this space. I'll try and track that and come back to you when there is actually a decision. That is my first of the year kind of warning, red flag, Title VII court decision for all of us compliance officers tweaking our programs as we enter 2025.
Karen, first of all, I want to thank you for bringing to all of us, both the panelists and our listeners, the new legal term, stray remarks. I'm definitely going to incorporate that into my repertoire. But here's the question I want to have to you from the compliance perspective. The Department of Justice has said that the chief compliance officer and the corporate compliance functions are the holders of institutional justice and institutional fairness in an organization. Typically, a Title VII, EEOC, or other discrimination claim goes through the HR department. Should compliance get involved? Should they oversee? Should they put a rigorous investigative protocol in place, starting with a triage of the claim and moving forward? How would you suggest the compliance function use this court case, if at all?
Yeah, well, one thing, Tom, that I'm seeing is, you've got here a relatively small organization. The YMCA nationally is enormous. This is a regional division. So you've got to question, if you've got a few hundred employees under your jurisdiction, how much rigor in your compliance program can or should you put into place? So I think that small organizations or subsets of larger organizations are always struggling with their own resources and appropriateness. But certainly, absent the appointment of a formal compliance officer, there needs to be places where people can go to raise issues. I'm a big fan of ombuds programs where you kind of take HR out of the picture for these types of concerns, because HR has got that kind of primary defense of the organization and all of their procedures to consider. So who could this woman have gone to in the moment to have had some sort of feedback before feeling that her only recourse was to the court or to the EEOC, which was avenue to her. So I think that's one issue. The other issue, when you ask about putting these systems in place and and the role of HR is we saw with the recent amendments to the evaluation of corporate compliance programs that the DOJ published, this increasingly broad responsibility for risk identification and risk management placed on the shoulders of the compliance officer and the compliance officer's department that go well beyond what we might have thought of as the 7 elements of an effective program, and starts really talking about the interaction between the compliance office and all the other functions, whether they're business units or functions like procurement and HR and business development, where compliance is, as I said, uniquely positioned, but also now seems to have this increasing responsibility to interact with those departments and highlight to them their responsibility, their need to adjust, their need to interact with compliance in speak up systems, in monitoring systems, in auditing, in reaction, in document creation. So I think compliance role is expanding. And the question really has to be now whether the resources are going along with it to allow that to happen.
All right. Mr. Armstrong, what is on your mind in early January of 2025?
Well, thanks very much, Tom. And again, Happy New Year to everyone. As I think mentioned on this podcast at the back end of last year, I had the privilege of traveling to work and to speak at events in Korea. And I'll say from the get-go, I want to apologize to all of the friends I met in Korea for the butchering of the language which is about to which I'm about to engage in. But I also want to say that my thoughts and prayers are still with those people who are victims of the Muan airport tragedy, which happened after I'd left. The talk when I was over there, which has remained, I think, the talk in Korea with recent political events, was around handbags. So let me explain. In September 2022, it seems that the First Lady of Korea, Kim Kyung-hee, met with a pastor, and the pastor had a nice chat with her, and it seems gave her a Dior bag with a value of around $2.2 thousand, so under $2,500. And he gave her the bag, and no one really knew anything about it, it seems, until the February 2024 elections, so some 18 months later. And then a film was leaked, which seemed to have been taken by the pastor's watch, which showed the First Lady accepting the bag. And that obviously hit the headlines, particularly at election time. It struck hard for the Korean people because the President Yoon, had stood in part on an anti-corruption ticket. He'd been a former prosecutor, and he'd had a part in the prosecutions of 2 former presidents for corruption allegations against them. So President Yoon knew that he had to do something, and he held a press conference, and he said that the events were regrettable, but he didn't apologize. And we could talk about culture, but in the Korean culture, obviously, an apology from a politician would be something more common than an apology from a politician in the US. But he didn't apologize, and he dismissed the leaking of the footage as, quote, a political maneuver. When he was asked to expand, or when he expanded on what was regrettable, he said that the thing that was regrettable was that his wife had been unable to have the, quote, cold heart to reject the pastor. So he didn't really accept didn't really seem to accept blame. That led to comparisons of the First Lady to Marie Antoinette, which she started to be called, I'm told, in Korea. And more allegations then came out about her and her family and their business interests. There were repercussions around the seeming lack of investigation into this incident. And that then led to a bill in the Parliament to effectively investigate and to sort of force the state investigator, as I understand it, to get more involved. And that was the bill that the president vetoed. And when opposition kicked up to him vetoing that bill, he took the perhaps surprising step of declaring martial law. Now, I think most people know the back end of the story and martial law being declared, but perhaps they don't know the front end of the story and how it sort of starts off effectively with a corruption case. So what's the relevance of that to corruption, to compliance officers? Well, obviously, there are going to be more sensitivities when looking at corruption investigations in that part of the world, because corruption is headline news, and because many of the Korean people have seen the instability that brings, or at least allegations of corruption brings. But maybe there's 5 other things. Let's replace last month's 5 gold rings with 5 sort of illustrations for compliance officers that the case brings us. First of all, I think it illustrates what I call the say-do gap. So many executives, many organizations suffer from this say-do gap, this difference between what they say and what they do. So to give you an example, coming up to the London Olympics in 2012, we had a client where obviously the Bribery Act was very new. Hospitality was a key area of focus, it seemed, for the Serious Fraud Office. And so my client decided that it was not safe to entertain people at the Olympics. So one of the divisions of the business had planned to take a corporate hospitality package at the Olympics to bring customers in. The business decided as a whole that that was too risky, and they rolled out of that hospitality package. So imagine the terror in the eyes of the people who took that decision when the CEO was photographed being entertained in a much more lavish setting by at the Olympics. Not only was he being entertained in a lavish setting, but he'd flown all the way over from the US to be in London to attend an event where he'd agreed nobody could do entertainment there. So that's a really big say-do gap, one that I think in some respects I still do work for the same organization, and they still have a legacy of that. The remedial measures they had to put in place, not only in more training for employees, not only for a sort of Korean style apology from the CEO, but we're still doing work with suppliers to reinforce those messages that were undermined by this say-do gap incident, 12, 13 years ago. Secondly, I think the case tells us that whistleblowers have to be acted on. You can't fetter the investigation, and you can't tie the hands of investigators. Thirdly, I think you need to have clear policies on what's prohibited and what isn't. Obviously, $2,200 would be enough to trigger policies in most organizations. You've got to know at the level you're setting. Fourthly, CEO risk. We've talked about it before. Karen's talked about it already today. As a general rule, compliance organizations are getting much better at pushing compliance down in the organization. They struggle with pushing it up. And the very top of the organization, the president, the CEO, has got to take compliance seriously. Even the president's spouse has as well. And then I guess the fifth message is, I guess, going back to the days of Troy and a modernized version, beware of pastors with camera watchers bearing gifts. So they're my thoughts, Tom.
Well, I must say you have elevated the bar following Ms. Moore for Ms. Woody and Matt Kelly, because now we have not simply the new legal term stray remarks, we have the compliance term, the say-do gap. So you've really, really taken us up. Karen, lots of pressure on you now.
I am going to acknowledge off the bat that I won't be able to, raise my rhetoric to that level at all today. I'll give it a whirl, but probably will not. I mean, I never can keep up with Armstrong. Nobody can. But today, Tom, I'm going to talk about the CFPB. If it's my turn, I don't want to jump ahead unless there are questions for Jonathan.
I think it's your turn.
All right, I'll go ahead then. So like I said, I'm going to talk today about the CFPB, the Consumer Financial Protection Bureau, which is something I think most of us are aware of and have heard a lot about in recent months, if not in the last decade. It is, I think, going to be in line with what I discussed last time on this podcast, which is where do the agencies stand in Trump 2.0? And so a lot of this will be a bit of an echo from what I was saying even last podcast about some of the issues that we'll see maybe with the SEC. The CFPB, for a lot of reasons, is more, I think, of a lightning rod than the SEC. It was set up after the Great Recession, sort of the 2008 crash, and essentially built upon what was really a proposal, sort of a framework that was pushed a lot by Elizabeth Warren. So right there, you can see that there was a lot of political backstory to this agency that was, seen as a bit of a lightning rod, just sort of ab initio, like from the get-go. It had, some controversy to some extent. But, despite that beginning, it has been around now for almost for a while, and it has been a resounding success by every measure. It has returned almost $21 billion back to consumers based upon, its ability to recoup monies from activity that is illegitimate, that was done by financial institutions. So you can think of things like initially this was mortgage issues that we saw, sort of that was the inception of some of the Great Recession. More recently, it has tackled issues like medical debt being attached to your credit scores. Just in the last month, the agency succeeded in reducing the maximum amount of overdraft fees that were required by credit card companies. So they were able to remove the $35 overdraft fee and bring it down to $5, capped at that. And same with credit card late fees. There was a reduction of almost 80% done by, the CFPB under the Biden administration. So, it's hard to attack this in some ways because it's been so successful in doing what it was aimed or set up to do, which is to help consumers against sort of the greed and maybe nefarious activities being done by Wall Street. So it really is sort of a Main Street versus Wall Street, sort of it's at that crossroad of trying to stand in the shoes for the average Joe kind of thing. So you can imagine then when it's created and has that backstory, how it lines up politically. And so, of course, we might recall that, in 2017, when Trump first took office, his first acting director of this agency was Mulvaney, who asked for a $0 budget and had called the agency a joke that he was then in charge of. So, sort of this harkens back to, a lot of what we saw in Trump, the first administration, where we just put people in charge of agencies who didn't believe even in the goal of the agency itself. We saw that across, I think, the administrative state in the first administration. And I think we might see some of that again in this administration. Mulvaney then was replaced. He was just the acting director, but he was placed by this woman, Kathy Kraninger, who took over in the Trump administration. And she, as maybe predicted, gutted some of the crucial rules that had been enacted under the Obama administration that were protecting consumers for things like payday loans, car title loans. There was a lot that she sort of rolled back. But Andy, of course, relaxed a lot of the requirements for financial institution reporting. She just relaxed a lot of the progress that had been done in the first few years of this agency regarding even the things like the mortgage disclosure rules and things like that. So I imagine we'll see something like that. Obviously in the Biden administration and certainly under the agency head Chopra now, we've had this aggressive rulemaking, this more aggressive sort of attempt to recoup funds for consumers at the expense of financial institutions. And I imagine we'll see this pushback coming back again. So I will say a few things, though, about that could be considered sort of lights at the end of the tunnel here. And the first is that those of you who are, in this space might appreciate that this agency was challenged. I mean, this has been challenged as in the legitimacy of it at all, whether or not it was an overstep to set up this agency at all. That went all the way to the Supreme Court in the first Trump administration. And it was decided 7-2 in an opinion penned by Clarence Thomas that the agency was legitimate and even its funding source was legitimate. So sort of the ultimate challenge to this agency has failed in its first administration. So I think it is here to stay, but in what form it will take, it will be interesting. So looking forward to Trump 2.0. Again, it's no surprise that Trump and his sort of minions and acolytes certainly do not like this agency. Elon has called for its termination. It's listed under Project 2025 and the Heritage Foundation publications. They want this thing gone. Representative Andy Barr out of Kentucky and also I think Tim Scott out of South Carolina. Those two are holding, significant positions of power at the House Financial Services and the Senate Banking Committee, respectively. And they have already introduced some legislation aimed at really gutting and, reworking what the CFPB is. So just last month, I guess it was about over a year ago, Representative Barr had introduced legislation trying to completely rework the CFPB, changing it from being a 5-person commission down to a single person, making sure it's no longer part of, any sort of broader organizational structure in terms of having a link to the Federal Reserve, all these sort of the ways that the agency is set up. He's trying to attack it sort of at the ground level. And so it looks like there could be some real rough sledding going forward for this agency and all of those who are in its employ. But I will say, again, another couple, I think, potential, granted, end of the tunnel type bright lights is it's at its own potential peril for the Republicans to go that hard on this. Because first, Trump at least gave lip service in his campaign that he was a populist. I mean, we all apparently have this president because we expect our grocery bills to go down. He even, I think, on the campaign trail had at once posited that there should be a cap on credit card interest rates. So I say this just because it could really be a minefield to try to take on this agency that is really sort of, the champion of, like I said, sort of average Joe the plumber, whoever from the first time, or just, this Main Street versus Wall Street setup. How long, no one would be surprised if Trump, turns around and does something against what he said. So I don't think there's much that we can really, hold on to in that sense. But it would not be a great look, I think, to have significant congressional hearings where the CFPB can come in and talk about how much it has done and given back to consumers on, clearly fraudulent practices, of certain financial institutions. It just wouldn't look good to have a real flashy sort of out in the open debate over the merits of this agency. I do think there'll be a lot done in the undercurrents. So, I'm sure we will get trying to roll back this medical debt, the overdraft, credit card fee stuff. That'll all come in ways that I think this next director might try to undermine what has been the progress of the agency. But in terms of, I think, full scale removal, whatever Elon is calling for, I don't think that's hopefully not in the cards for this agency. But like I said, a decent amount of rough sledding for the CFPB.
Matt, do you have a question or comment for Karen?
Probably a little bit of both, but first, Karen, I agree with you 100% that I think the CFPB is a canary in the coal mine for any compliance officers who want to understand how Washington might try to treat regulatory agencies. But also, I do think, they're going to have a real struggle trying to do structural reforms or to make it go away or anything like that. But correct me if I'm wrong. My big thing about the CFPB is that according to the Dodd-Frank statute and other CFPB rules they've put forward, even if the CFPB did nothing or just sort of disappeared, then the enforcement powers that it has would devolve to state attorneys general and banking regulators and whatnot, which I think is an important point for compliance officers to remember, is that this enforcement risk is not going to go away. It's going to change. And in fact, that's what I'll talk about in my segment next, not the CFPB, a different sort of example what I mean. But it's not like this is going to result in any less of a headache for compliance officers in finance. It's just going to change the nature of the headache you have, I think. Is that right?
Absolutely. And I actually meant to say that in my sort of light at the end of the tunnels. That was the other one. Like, I think it's going to be, a near impossibility to get rid of it entirely. I think it might be effectively dismantled by, as you said, just absolute zero work done, or even the work done is to sort of run against what it already has accomplished. But I do think you're exactly right. There is nothing that keeps states from enacting similar type rules. So states certainly can enact their own state laws that protect consumers. And so I think there could be a lot of gap filling we'll see, and certainly maybe some of the more left-leaning states or blue states, which, as we know, also hold a lot of companies and businesses and, have a lot of people who live there. And so there could be, I think, significant gap filling by states. And so I think you're right that it's not going to go away, but people are going to start really, as you say, appreciating the blue sky laws or the equivalent of blue sky laws in the consumer protection space.
Well, Karen, you may not have coined a new phrase for us, but you have actually given us a new meaning for an existing phrase. And that phrase, of course, is penned by Clarence Thomas, which you've changed to me something positive. I've never heard that before.
No,
so there you go.
Surprises you.
Matt Kelly, you got an incredibly high bar. So what do you got for us today?
Well, I actually we do have an enforcement action already in 2025 that I thought was fairly interesting that I wanted to bring to compliance officers' attention. It might at first glance sound kind of nerdy and obscure, but trust me, I'm going somewhere with this, listeners. This was a case against a big mortgage player, the home mortgage market, Bayview Asset Management, where they were sanctioned for poor cybersecurity practices by a coalition of state banking supervisors. So the way that this happened is that Bayview Asset Management is an investment fund, and it specifically works in home mortgages at non-banks. And there are several different non-bank home mortgage providers out there, several of them subsidiaries of Bayview, or Bayview controls them. There's a total of 4 business entities that were swept up in this: Bayview and 3 of its, I'll call them affiliates, but they are home mortgage servicers, or they issue home mortgages, or they manage the mortgage after you already get it, things like that. So what happened was that in 2021, some poor employee within that corporate empire, they accidentally infected the network with malware. And the network for all 4 affiliates is managed all by Bayview. But anyways, malware attack strikes the network, and this leads to a data breach of some 5.8 million customers. The state banking regulators, acting in concert under a group known as the Conference of State Bank Supervisors, which I didn't know was a thing until Tuesday when this enforcement action was handed down. But the Conference of State Bank Supervisors acts as this unified investigation and enforcement unit for all the state supervisors when they want to do that. So 53 of them, because apparently there are several states with multiple banking regulators and 1 or 2 territories in the District of Columbia, but they launch a larger probe into Bayview's cybersecurity practices for all of 2020 through 2022, not just that 2021 malware incident. They find all sorts of bad practices. This is the stuff that might sound kind of nerdy unless you are an IT security person, but they had evidence of weak IT patch management, weak centralized oversight of how they identify IT vulnerabilities, how they make sure those are getting fixed, failure to track IT inventory, failure to encrypt personal data while it's at rest, several other bad practices. It reads like a greatest hits of how not to handle your IT security. But that was exposed. And so now we get to what I think is the bigger interesting thing is the remediation steps that Bayview has to implement. And it's not just about cyber. The issue Bayview has to handle is cyber. But the structure of their remediation plan is what caught my attention, because I think the structure of it is relevant for many different companies that have many different issues. Bayview's issue is cyber. Your issue might be anti-corruption or harassment or who knows what. But the broad structure of what Bayview is supposed to do, that's the thing that strikes me as very sensible for large companies that are struggling to get things done, which is pretty much every large company I have ever heard of. They have to work at 2 levels. First, senior managers at all 4 of those affiliates, Bayview and the 3 affiliates, all 4 entities. They have to have a corporate governance framework that sort of drives senior management to keep its head in the game on IT security risks. So for each affiliate, their framework is going to have to require that management makes sure you have a written information security policy that has to be reviewed and updated every year. Review and update the business continuity plan at least every year. Review and update the incident response plan. Review it every year, update it as necessary. And that plan for incident response has to pay particular attention to the roles and responsibilities of the IT security team that works underneath senior management. But really, that whole thing just means senior management, as you're reviewing your incident response plan, please give some thought to who's doing what to make sure that when you say this shall be done, the right people are doing the right things so it gets done. And then make sure that there are written policies for configuration management, data protection, identity access, IT vendor management. So that's a lot of stuff. And Bayview and its minion firms, they're going to have to get pretty granular about their IT risk management efforts. But I think the whole point here is that it drives senior management to think about cybersecurity risk at a big strategic level and not just at an operational level. You know, here's our business. This is how we're doing it. We know cyber's a thing. You peons in the IT security department, please make sure we have no cybersecurity risk. That is a terrible way to treat it from now for the rest of eternity on this planet. So it really, the framework makes senior management think about how will we have a secure business as we move forward? How are we sure that cybersecurity capabilities are strong and woven through the whole firm? That's part 1. And then part 2 is more lower level for the actual IT people who are in charge. They're going to have to come up with a risk management plan. And that plan has to be in accordance with several specific cyber rules. One is for New York State. It is known as NYCRR Part 500. The other one is for the safeguards rule from the Federal Trade Commission. Those are just basically rules that talk about good data protection. The risk management plan the IT people come up with has to be in accordance with that. They're going to have to come up with more specific plans about how are they actually going to track all the IT equipment? How are they actually going to track all of the IT vendors? But importantly, at the end of all of those, how are we going to do issues that they have to take care of? How are we going to report what we're doing in some sort of cohesive form back up to senior management? Because according to their framework, they have to be asking about what's going on. And given what's going on, is our plan that we review and update annually, is it on track? So if you take these two things together, it really does demonstrate how senior management and different business functions work together well to tackle a specific risk. And like I said, with Bayview, this is about IT security, but we could take the same principles and apply them to anti-corruption, to ESG issues, to sexual harassment and HR issues. It's really about how does senior management structure itself and discipline itself to take these risks seriously, give them the attention they deserve, and how do lower level teams build an actual program to tackle the risk and create the right information to put into a report that goes back to senior management. So when they review and update every year, they're reviewing and updating based on complete, thoughtful analysis of what the actual risk is. So I did write about this on Radical Compliance. Like I said, that I know that a home mortgage scheme might not seem like terribly relevant to a whole lot of people, but the structure of the remediation is what's interesting to me. And then my last point is, this is, like I just mentioned with Karen Woody, this is a reminder that even if the feds under the Trump administration just sit around and twiddle their thumbs for 4 years, the risks are still out there and they're going to be addressed by somebody else. State attorneys general in particular are delighted to pick up consumer protection cases because that makes them look good when they run for reelection or for governor or Senate or who knows what. But a lot of what we're talking about with deregulatory this and that and everything else at the federal level, I think it's like hammering a puddle of water. The water's just going to splatter somewhere else. You will still have things floating around that are going to splatter on you. And that's a point that you cannot ignore if you're a compliance officer right now.
All right. That was a great case to review, Matt. I think it was under the radar of a lot of anti-corruption compliance professionals. So I wanted to thank you for bringing it to everyone's attention in this episode. And now we're off to fan favorites, shout outs and rants. I know people have been actually thinking about these for a while. And we're going to keep the same order. Karen Moore, Jonathan Armstrong, Karen Woody, Matt Kelly, and I'll bat fifth. We may have some overlap as well. So Karen Moore, shout out or rant. You're muted.
I was trying to be a good, quiet team player. I was going to give a little mini rant here on Meta and its decision to end its fact-checking program in favor of a community note system, as if the two actually shouldn't be going hand in hand. But I just wanted to say that the BBC Today Show podcast has an excellent conversation on this that dropped yesterday. So direct everyone there, because what I really would like to do from the heart is just memorialize the passing of Jimmy Carter, our 39th president, a man of tremendous integrity, a statesman, a father, a husband, somebody who really exemplifies some of the best of who we can be. Arguably, maybe not the most successful president, but I entered high school as he started his first days in office, and I turned 18 as he attempted to expand his presidency into a second term unsuccessfully. But so that was my first foray into voting in our great system of democracy and election, and trying to make your voice heard. I was in high school in New Hampshire, so actually was particularly exposed to Carter, as New Hampshire was, at least at that time, one of the really important early bellwethers for the presidential elections. I know from my own formative teenage years what a difficult time the mid to late 70s were for the country. Tremendous inflation battled into submission, resulting in a recession, the gas crisis, the Iran crisis, the invasion of Afghanistan. Carter may not go down into the record annals as one of the world's best presidents, but he certainly did what he needed to do with honesty, with integrity, with tremendous use of diplomacy in a very difficult time, although I start to feel like when has not been a difficult time. But more importantly, I just wanted to comment on what he did in the 4 decades post-presidency to leave a legacy, whether it was through Habitat for Humanity. I think most of us have at least rolled up our sleeves on one house to help house the homeless, or with the Carter Center, or with my continued contact with Carter, a good 10 years after that high school experience when he started to teach at my alma mater, Emory Law School, and came and worked with our international law class. So just a man to be admired, and I think we need to remind ourselves that they do exist in this day and age. So Jimmy Carter, number 39, 100 years of statesmanship, family orientation, integrity.
Mr. Armstrong.
Yeah, here to that. I decided that as part of my New Year's resolution, I was going to stop ranting about serious politicians. So instead, I'm going to talk about Liz Truss. And it's a litigation alert this week. Liz Truss, you may have seen, has sent a cease and desist letter to Sir Keir Starmer, threatening him with legal proceedings. Now, nothing, I have to say for professional reasons, nothing I'm about to say should be taken as a criticism or comment on the actions of Liz Truss's lawyers. However, the letter, and I say read it in full because I'm unable to paraphrase the 5 pages of legal argument. The letter alleges that Keir Starmer keeps repeating that Liz Truss, quote, crashed the economy. And Liz Truss's various observations or defenses to the allegation that she crashed the economy are, I think, varyingly described as not me. It was the Bank of England that did it. It was someone else's fault. It didn't happen. Or this was all a coincidence. And the more extraordinary argument, it seems to me, which I admit I'm not intelligent enough to follow, is that Keir Starmer should have known in May 2024 the contents of a letter that he was sent in January 2025 with an expert opinion that said Liz Truss wasn't to blame. I'm obviously not clever enough to understand that argument. Now, what happened as a result, allegedly, of the claims that Liz Truss crashed the economy? Well, Liz Truss lost her seat in Parliament, and the letter seems to allege that Sir Keir's remarks were wholly responsible for that. Now, Liz Truss had a majority in Parliament of 26,195 in 2019, and she, or perhaps Sir Keir, managed to turn public opinion against her to the extent that she lost that 26,000 majority. For statistics, that's a loss of 43.4% of the people who'd voted for her. So almost half, it seemed, turned against her. Now, for full disclosure, I should say that Liz wasn't the only candidate who became less popular in Southwest Norfolk in 2024, because that would be to forget the election loss of the Earl Elvis of East Anglia, the monster raving loony party candidate and sometime reincarnation of Elvis, who also lost 0.9% of his votes compared to Liz's 43.4. Earl Elvis of East Anglia will be, of course, well known to compliance officers because he had a proposal to fund a frivolous fraud office, because he said the serious fraud office should have focus on serious fraud and the frivolous fraud office should do other stuff. But let us reflect for a minute on Liz's record. If she's right, and by the way, it seems that her legal letter does not comply with legal protocols, but leaving that aside, she doesn't seem to take into account, firstly, parliamentary privilege, which allows politicians to say things in Parliament with a measure of protection. And secondly, public interest, which can be a defense to defamation proceedings. She perhaps doesn't comment as well on a truth, which can be a defense to defamation as well. I am not expert enough to decide whether she crashed the economy or not. But as I say, let us reflect on what would happen if her propositions were to play out. Effectively, we'd replace the ballot system with the opinion of judges, wouldn't we? Judges would decide who stands for election. Judges would decide who wins and who loses. And that would disenfranchise the good people of Southwest Norfolk, and it would turn democracy into a farce. So whether or not Liz Truss crashed the economy, my worry is that taking her arguments to the end result, they'd crash democracy.
Well, Karen Woody, following that note, what do you have for us?
I have a bit of a rant. I don't even know how to sum it up. It's such a large rant, but it starts from a place of concern and just sort of a level of desperation I think we all feel about the LA fires. And so my rant is that, especially in this new era of Trump and companies that are exiting any sustainability protocols and rolling back all of this progress we tried to make under this, what I thought was just nearly a given, that the planet is getting warmer and we have extreme weather events. And the idea that people just want to keep denying that, or to create policies, or to just chase money at the expense of these people's homes and livelihoods and animals. It's insane, the level of destruction. I'm not from LA. I haven't even spent much time in LA, but to me, this feels almost like the Twin Towers, like these iconic landmarks, this sort of beautiful area of our country that has just been carpet bombed. It looks like when you look at these pictures, it's just beyond devastating. And so I just, if nothing else, feel like there should be, at least at this point, after North Carolina's hurricane, after there's now, snow across the South and this fire in California, to me, it's like, how is there not at least a Pascal's wager on this? Guys, it just makes more sense, whether you believe it or not. It's the loss that you could potentially sustain, even if you don't believe in this, is now outweighing whatever nonsense that you want to claim and cling to, that there is not significant climate change occurring. And I don't even think rant sums it up. It's now just nearly despondency looking at these images. So my heart goes out to LA, and I hope everyone there is staying safe. And also, I guess, in in the same side of that coin is a shout out to all those who are helping, especially, of course, people who are putting themselves in harm's way to help.
Matt Kelly.
I'm actually going to follow again on what Garen Woody was just saying, because today I decided to give a shout out related to the LA fires, specifically to the actor Steve Guttenberg, who is now 66 years old. For those of you who don't know, he was a big movie star in the 80s and still keeping it real, living in LA. His last big film, it looks like it was Sharknado 4. But he is, like I said, 66, probably living off the residuals from Cocoon and Police Academy and all the others that he was in. And he spent this week, apparently his neighborhood was not affected by cars. So we went over to neighborhoods that were clogged with cars that had been abandoned and was trying to move them and just testing cars. If people had left their keys there, then he moved them off to the side of the road so fire trucks could get by. And he was interviewed on the news, and I am not entirely sure that at first the young TV news reporter knew who they were interviewing, because Gutenberg today, like, his best days are behind him, but he's still showing that he's got a lot of good impulses and good days today. So thank you very much to him, and of course to everybody else who is trying to fight the fires out there. I know one or two people who have lost their homes, and a few more who are in danger of losing their homes. And we are all thinking of you. That's it.
Well, I'm going to end on hopefully a little more positive note, and I'm going to pick up on Karen Moore's shout out. I want to shout out to Gerald Ford and Steve Ford. Gerald Ford was defeated by Jimmy Carter for president in 1976. It was the first election I voted in. And after President Carter was defeated by Ronald Reagan in 1980, President Reagan asked ex-President Ford and ex-President Carter to do a mission together, a political mission for him. And from that, they became fast and best friends, to the point where the only other former presidents who were that close of friends were Thomas Jefferson and John Adams. And they made a pact that they would speak at each other's funerals, or they would have their remarks read. And so Jimmy Carter spoke at Gerald Ford's funeral, and obviously President Ford predeceased Jimmy Carter. So Steve Ford spoke and read remarks that his father penned at Jimmy Carter's funeral. For those who may not remember Steve Ford, he was a huge Peter Frampton fan after Frampton Comes Alive came out in 1977. And now I want to, he talked about the friendship they had, and he talked about the relationship they had. And here's the words he ended with. And he teared up while saying this, quote, "As for myself, Jimmy, I'm looking forward to our reunion. We have much to catch up on. Thank you, Mr. President. Welcome home, old friend." And there was a time when American politics, that was how American politicians treated each other. I wanted to shout out to Gerald Ford. I wanted to shout out for Steve Ford. If you haven't seen the video of President Carter's funeral, I would urge you to do so. And that will conclude our first episode from 2025. I can't wait to see what we can come up with next time.